So I get what you're saying. What you want to know is, can you put it in the agreement that there's no traveling during the holidays? That way you avoid all the problems. Well, I'll tell you, you got to remember one thing. This is a contract. As long as it's not unconscionable, the parties can agree on whatever they want. If it's determined to be in the child's best interest that no traveling occurs, let's say, God forbid, you have a severely developmentally disabled child, so no traveling can occur. You put it in the agreement, that's fine. It should be clearly specified, clearly defined in the agreement. And if so, there can be restrictions. The court can order that out-of-state travel, for example, is restricted. This can certainly be done, but you got to understand one thing. Because violations of these restrictions can result in court action, the court's going to take it very seriously before it makes a determination that nobody can travel. So even if the court made a determination 2 years ago in the original agreement that all parenting time is within the state of Michigan, remember one thing, and that is that it can be modified if with court approval, if it's in the best interest of the minor child. Now, I cannot tell you how many times we've seen situations where one parent has a holiday, wants to take the kid to Disneyland. Other parent objects. You're not supposed to leave the state. You know what happens at those hearings? The court looks at the motion, looks at the request, looks at the objection, and then turns to the other side and say, give me one good reason why you don't want your kid to go to Disneyland. Well, this is not blah, blah, blah. Nonsense. I wish I had a chance to go to Disneyland when I was a kid. The court believes in Disneyland. Disneyland's good. It's his time. I'm modifying the agreement. Expect that to happen. Because when you don't have a darn good reason why your kid shouldn't have an enjoyable vacation, it's obviously going to look like you care more about the fight than what's in the best interest of the child. Now, there can be good reasons. This child can suffer from horrible food allergies, God forbid, and in an environment like Disneyland, it cannot be controlled. You're worried about cross-contamination. You're worried about something that has to do with the best interest of the child. And the court will hear this. Might not agree with you, but it'll hear it. But if you come in there, making it look like it's all about you and not about the child, that's a motion you're going to lose. So bear in mind, so can the agreement have a no travel clause? Sure it can. But remember, subject to modification based on the court's order.